Okay, now I see YouTube live. All right, welcome to the this morning's session of the Kansas Court of Appeals via Zoom in this time of COVID. I appreciate the attorneys in this case being willing to use this system of oral argument and getting themselves ready for a Zoom oral argument. This is being recorded on YouTube, so everything that you say and do will be available for your friends and family to watch, of course, as well as your clients and their families. I'd like to introduce to you the panel with me today. We have Judge Tony Powell, who was formerly a district judge in Wichita, and we have Judge Catherine Gardner. I am Chief Judge Karen Arnoldberger, and I'll be the presiding judge today. And all that means is that I get to keep time for you all. And you'll learn pretty quickly that I'm not very good at that task as well. We know the facts of your case, so you each have 15 minutes to argue. You don't have to spend a lot of time on the facts because we are aware of those. You'll also notice that we may be looking to the left or the right while you're arguing, and that's because we have other screens up, as you probably do too. And I just want you to know that we're not ignoring you. We're just looking at briefs or other items on our monitors. All right, with that, Mr. Osborne, did you wish to reserve any time?
Yes, Judge, if I could reserve 5 minutes.
5 minutes, okay. And why don't you both state your appearances officially, please?
May it please the court, the appellee in the case, the state of Kansas, appears by Assistant County Attorney Megan Williams.
Okay.
May it please the court, the appellant T.W.T. appears by counsel Joseph Osborne by Zoom.
Okay, thank you. Mr. Osborne, whenever you're ready, you can proceed.
Judge, I think largely my brief speaks for itself, and I'm not going to spend a whole lot of time rehashing it. I would just take a moment here to address a couple of points that the appellee has raised in their brief.
Okay.
And firstly, I would argue that this court does have jurisdiction to hear this type of an appeal.
Yes, I think that's exactly what we'd like to hear your thoughts on.
Certainly. And while I understand that the right to an appeal is a statutory right, I believe that the statute under the revised Juvenile Justice Code does provide a right for an appeal in this case. It's specifically subsection B of 382380, orders of a judgment and sentencing. I would argue that a motion to modify sentence is an order, or is a sentencing, at least for purposes of this statute. I think just on its face, this court has heard a number of cases that have arisen as a result of the modification statute. So to my mind, it would be fairly straightforward that the Court of Appeals does have jurisdiction to hear
You're saying that in a juvenile case, we have heard motions to modify sentence on appeal?
You have, Judge.
And could you tell me the cases that we've done that in?
Certainly. I believe they would be the two unpublished opinions that both myself and Ms. Williams have cited in our
okay. All right.
briefs,
Okay.
which are SDS and CMW.
Okay, I've got those. Thank you.
And then beyond that, I would just, well, largely I rest on my brief, but I would note that that my client has made every effort to exercise his rights. I understand that the court can't go back in time and solve the problems if there were problems with his district court, with his trial counsel. But what we're looking at here is a young man who, at the age of 16 was tried without a jury and sentenced in a fairly heinous crime. And I think that the court has the opportunity here to provide both a sense of, I don't want to say justice, but a sense of fairness, at least procedurally, to my client, and to provide guidance for future attorneys that have to address these issues. And with that, I yield the floor to Ms. Williams, unless the court has questions.
I do have a question when you're talking about asking this court to give you guidance. what do you view the role of this court as? Is it appropriate for us to do that when the legislature hasn't specifically listed the factors that a court should consider in determining whether to modify the sentence or not?
I think it's appropriate in that obviously the court's role, at least in large part, is interpreting these statutes and these rules. And to the extent that the legislature has remained silent and left the issue ambiguous, I don't know who else would have the opportunity to address this and to provide guidance for practitioners.
So what are our parameters? Do we just make up factors out of whole cloth? What should guide our determination? What do you suggest?
Judge, my thought would be that there are factors provided in the statute, simply not under this subsection. And if the district or if the legislature had, intended that to be silent, they wouldn't have put factors in the other sections and then left this one blank. I think that there must be some sort of guideline. If it is at the court's discretion, at the district court's discretion, then that's fine. But I think it would be good for practitioners and for juveniles to know that going forward, that if it is silent, then it's up in the air.
Thank you.
Okay. Any other questions from the panel? All right, Ms. Williams.
Thank you. I guess I would like to first address the jurisdictional issue that there have already been a couple questions about. It's the state's position that the court does not have jurisdiction to hear this appeal. If you look at KSA 38-2380, there are two types of appeals that a juvenile could appeal: order authorizing prosecution as an adult and an order of adjudication or sentencing. There are some cases that have dealt with that statute. One of them that I cited in my brief, the DMT decision. I think that case is really on point with procedurally where we're at in this case. That was a situation where the juvenile had been adjudicated a juvenile offender and sentenced, had pursued a direct appeal, and after that direct appeal failed, he then filed a post-adjudication motion to set aside his plea and sentencing, his adjudication and sentencing. And the Court of Appeals, as well as the Supreme Court, dismissed it for lack of jurisdiction, specifically stating and reiterating that the right to appeal is statutory and that modifications of a sentence are not listed in the statute and so therefore are not appealable by a juvenile offender. Mr. Osborne had made some reference that a motion to modify is essentially a sentence. And I would note that there is another case that somewhat addresses that issue, the CDAC opinion that I also cited in my brief. And that was a little bit different because it was a probation revocation. Initially, that juvenile had been placed on probation, motion to revoke was filed. And so there were some arguments in that case about whether or not a probation revocation was a new sentence for purposes of the statute. And the court said no, that it was a probation revocation, and because it wasn't allowed by statute, that the appeal had to be dismissed. And so, quite frankly, I think that 38-2380 kind of speaks for itself on the jurisdictional issue because the statute does not allow for appeals to be pursued by a juvenile on a motion to modify sentence, that there is no jurisdiction for the court to hear this appeal. The two cases that Mr. Osborne had brought up, the SDS opinion as well as the CMW opinion, the SDS opinion was actually an appeal brought by the state, not by the juvenile. And the CMW opinion, the only issue that was raised on appeal there was whether or not the juvenile had a right to an additional hearing at the district court level on the motion to modify sentence. And so the issues in that case, I think, were a little bit different from what we're dealing with here in terms of a court's ability to review the merits of a motion to modify sentence and the court's reasons for denying that.
Ms. Williams, may I ask you a question, please?
Yes.
The procedure with regard to revoking a juvenile's probation, does the court have the authority when, like in adult prosecutions, to modify a sentence upon revocation?
Let me make sure I've got your question right. So you're asking when a revocation comes up before a district court, if the district court in a juvenile offender case can then modify that sentence?
Yeah, if they revoke their probation, but there's a request by the juvenile to have a reduction in sentence, for example, does the court have the authority to do that at that time?
I believe that the district court would have the authority to do that. We've seen plenty of examples kind of going the other way that you referred to, where they're initially placed on probation and after they've committed violations of probation, the court does ultimately either sanction them or sentence them or commit them to a correctional facility. So I do think that the court does have discretion to modify when it comes in front of the district court on a revocation.
Okay, so if the court, let's say the court does in fact modify the sentence and in fact imposes a new sentence, why isn't that in essence a sentence that is then subject to appeal?
So I think that's what the CDAC opinion addressed. I think those were the arguments raised in that decision because it was a probation revocation, and that was what they said essentially, that this is a new sentence, so we should be allowed to appeal it under 2380, and the Court of Appeals said, no, you can't. I would note, though, that even if the court did say, you know, a modification, if the district court has the authority to do that, in this situation, the sentence that he received was a sentence that fell within the presumptive sentencing range. He was sentenced as a violent offender 2, which allowed for a commitment to the correctional facility up to 22 and a half years of age, which is what he received. So in addition to 2380 not having any sort of statutory mechanism for a motion to modify as an appeal that a juvenile can pursue, there's also a prohibition in terms of his original sentence and being able to appeal that, because he was given a presumptive sentence, and the statute clearly prohibits those types of sentences being reviewed by an appellate court.
Of course, in the adult, and I actually agree with you on this point in the law, but I think the Supreme Court, at least in the area of adult prosecution, has said otherwise, that in a probation revocation, if the defendant asked for a modification of sentence and the original sentence was a guideline sentence and that motion's denied, there's still apparently a right to appeal according to our Supreme Court, and it's reviewed for an abuse of discretion. So I'm wondering why the same rule shouldn't apply here.
And I think because the adult criminal code and the juvenile offender code differ in terms of what appellate rights a criminal defendant has versus a juvenile offender.
Thank you.
You're welcome. The jurisdictional issue was the first issue I wanted to address, but I did want to also bring up the sentence modification statute if this court does decide it has jurisdiction to review the merits of this appeal. Obviously, that statute is KSA 382367. There are several subsections in that statute. The state's position has been, and I do believe that the counsel for the juvenile has agreed, essentially that subsection E is the applicable provision that we're dealing with here, because we are dealing with a juvenile that was committed to the youth correctional facility. And so that statute clearly says at any time within 60 days, the court may entertain a motion to modify. What that statute does not say is any sort of factor or finding that the district court is required to make when considering that type of motion. And so Mr. Osborne is correct, it is silent on that issue, but instead of that making it ambiguous, I think that actually sends a pretty clear message that the legislature was comfortable in the amount of deference that it was giving to a district court when considering these types of motions. When you look at 382367 as a whole, you do see subsection A, where it requires a finding that the original sentence not be in the best interest of the juvenile. And then just a couple provisions below that, you have subsection E, where it doesn't require that. I think that's a pretty clear sign that the legislature, if they had wanted to require any sort of factor or finding in subsection E, they clearly knew how to put it there, and they could have very well done so. In fact, just beyond 382367, there are other places within the Juvenile Offender Code where the legislature has exercised some sort of discretion over district courts. One example that I can think of is the statute that authorizes prosecution as an adult, 382347. That statute very clearly says to district courts, hey, here are 8 specific factors for you to consider when you're looking at these types of motions. Even beyond the juvenile offender code, if you look at the adult criminal code, for instance, KSA 216815 talks about aggravating and mitigating factors when considering departure motions. And even there, the legislature said, here's a list of factors, but it's a non-exclusive list. And so you see kind of a middle of the road option that the legislature's taken in terms of, well, we're going to exercise some discretion, but we're also going to give some deference to district courts. So I think we see kind of a continuum of total deference to a district court versus here are the list of factors that a district court needs to consider when it's looking at different types of motions. And with looking at the sentence modification statute, I think it's pretty clear that the legislature has said, we are giving deference to district courts when considering these types of motions. I don't think it makes the statute ambiguous at all. In fact, the CMW opinion that was cited by Mr. Osborne talked about 2367 and did say that there was some ambiguity, but specifically when subsection A, E, and F were read together. And I think there's some language in that opinion where it talks about when each provision is read on its own, it's clear. It's clear what's required and what's not. It's only when reading those provisions together that there's some sort of ambiguity. What the juvenile's asking this court to do essentially is to create some kind of legislation from the bench in terms of creating factors or findings that a district court should or has to make or not make when it's considering these types of motions. And I think that's something that courts refrain from doing. Clearly that is a task left up to the legislature. And I don't believe that that it's required or appropriate. Even if this court were to say, you know, looking at subsection E, we do think there's some ambiguity. If you look at 382367 as a whole, if you look at it in conjunction with subsection A and subsection F, conceivably then the only real finding or factor that a district court, when they are looking at that statute, the only finding that they could think they might need to make is a best interest finding, because that's what's found in subsection A. But in here, the district court did do that. When it gave its decision on the motion to modify sentence and it denied it, it did make a specific finding that it believed the original sentence was in the best interest of the juvenile, and that, and I believe I'm quoting here, that he should stay right where he is, or I might be paraphrasing. So I, you know, even if there's some ambiguity from a district court judge's perspective, I think that he made all of the findings that he even might have believed he needed to make. So I guess, Your Honors, those would be the two main points that that I would want to make. I guess in summary, the state's position is that no, this court does not have jurisdiction to hear this case, because what he's trying to appeal is not an appealable order. Even if the court does decide it has jurisdiction, KSA 382367 subsection E has very plain and unambiguous language. I think it's very clear that the legislature has given great deference to the district courts when deciding its motions, and the district court properly followed that statute, did not commit error when it denied the juvenile's motion to modify.
Any other questions from the panel? Thank you, Ms. Williams. Mr. Osborne, you have probably a good 10 minutes if you'd like it.
I don't believe I'll take that long. Just to briefly address Ms. Williams' points. I do believe that, to come back to the issue of jurisdiction, I believe she was raising SDS, the case SDS, for the proposition that effectively there should be an appellate right for the state in a case like this, but not for the defendant or for the juvenile. And I think that's, well, it's certainly on its face is a fundamentally unfair way to preserve the rights of the state and not the individual who's at the state's mercy in this case. I think with regard to the ambiguity of the statute, I have, I think, less faith in the legislature than the state does to have provided good guidance here. I think the legislature's silence, if they wanted the court to have full discretion or to give the district court effectively an open invitation to make whatever findings it would like, the legislature certainly could have said that. They could have said at the end of the statute, this is in the discretion of the district court. But they didn't. It's silence, and I don't think it's a particularly purposeful silence. I think it's ambiguous on its face. And then finally, I would note that while the district court did consider the best interest of the juvenile in the hearing held on this motion originally, it weighted that interest pretty heavily against the severity of the underlying crime and the interest of community safety. And while I would certainly not to poo-poo those interests, but I think if the main touchstone point is the best interest of the minor, then it would have been an error for the court to consider his best interest in light of the severity of the crime and then weight it against the community safety interest. But with that said, I have nothing further.
Okay, any questions from the panel? Okay, thank you, Mr. Osborne. Ms. Williams, we will take this matter under advisement and issue an opinion as soon as we can.
Thank you.
Thank you very much for your arguments today. We appreciate it.
Thank you.
Thank you.
Mhm.